Okay. So hey guys, we're back with the second to last session for Biorathon. Um, Sorry, I think my internet is a bit. Give me a second. Turn these off. Okay. Can you guys hear me well? Yes. Okay. So today we have Mark. Not Mark from VIOT, but Mark from Outlaw. So Mark's a good friend of ours. Has been he has helped us with a few of the projects and deals in the past, and today he'll be sharing a little bit about I think something that's very important for a lot of startups, especially in Web3 when you're dealing with like a very uncertain regulation, unclear landscape, legal landscape. So today Mark will be sharing a little bit about corporate governance and founders agreement, like for example, like what you do and there's a fallout between founders. So I'll let Mark take over from here. Mark, if you'd introduce yourself, introduce Outlaw, and then take it away.
Thanks so much, Long, and really appreciate you inviting us. I have with us our team member, Mikhail, also. I'll just give a quick intro of myself and then what we do at Outlaw, and then I'll dive straight. Of course, the topic that Long has shared is corporate governance and founders agreement, but we have expanded it to something broader. I think more importantly, corporate structuring, because that's something that a lot of startups in the space they are concerned with. And then the whole purpose of today's session, I'll try to make it as applicable as possible, i.e. to highlight key questions that we have received from clients in the past, etc., answer them, and then towards the end, we'll have like 15 to 20 minutes. If you guys have any questions, please do not hesitate to ask. To the extent that we can answer them, we'll do so over this call. If not, always happy to take it async. And feel free to reach out to Long if you need any help from us. So just to give you guys a quick intro by way of background, I'm born and raised in Singapore, corporate lawyer by training. So I did my bachelor's in Singapore, my master's in New York and NYU. Came from TradFi. So started my career as a private equity M&A lawyer with a Magic Circle UK firm Clifford Chance, and then I moved to Morrison & Foster Morpho. Likewise doing corporate work, but a broader ambit, including funds, venture capital. Right, about 2 years ago, co-founded Outlaw with my co-founder Mark, who is based in Dubai. We have 3 offices right now: Singapore, Dubai, and Korea. Korea is headed by our Korean partner, Yujun, who is a Korean qualified lawyer and also a partner at a boutique law firm there. So what we do, we support all our clients, primarily Web3 founders, projects, as their fractional in-house general counsel, taking them through 0 to 100 all the legal regulatory issues. Right, so that's a quick intro of us. I'll dive straight in. This is just let me just share my screen. Long, yes. I'll take over you, okay?
Yeah.
Can everyone see my screen right now? All good? Okay, I'll proceed. Okay, awesome. Thanks, Mark. Yep. So, quick one. As mentioned, today's topic is corporate structuring in Web3 founders agreement. I'll just keep this is basically the snapshot of myself, my co-founder, and Eugene, who heads up our career office. Of course, we have our team supporting us, and I'm very happy to have them as part of the family. I'll dive straight into the first one, which is corporate structuring. Guys, please do not. There's no need to take notes, okay? Of course, take whatever is important for you, but in terms of the slides itself, we'll share it with Long, and Long can circulate it to everyone thereafter. Take note that whatever we will be discussing as part of corporate structuring is high-level good practice, right? It by no means is the be-all and end-all, and it definitely will not simply just apply to your project. Ultimately, it's very specific to your business mind, but what we can share is a high-level overview of what good practice is in the market itself. Commonly, we see the Cayman BVI, the Panama structure, and then I'll just explain to you guys the key points of this structure chart. We'll start off with the Cayman BVI. Of course, you guys know on the left side, if you follow my cursor, this is the offshore structure, right? So usually you have a legal wrapper to make it decentralized, to perhaps set up a DAO. Right, there is, strictly speaking, no necessity to set up a DAO. It honestly depends on your business objectives and your commercial goals, right? But In terms of the offshore structure, which is primarily for token issuance, you generally will have a foundation at the top level, right? And then you make it shareholderless. So in both the Cayman Islands and also Panama, if you have a nominee supervisor in the Cayman Foundation, you don't need to have shareholders. Likewise, in Panama, if you have a nominee counsel or counsel, you don't need to have any shareholders in the foundation itself, right? So this helps further the decentralization aspect, because if there are no shareholders, right, you can implement the DAO structure if necessary through a governance mechanism. Beneath the Cayman Foundation, usually you have one or two entities, right? Primarily a token issuer. So take note, token issuing in itself is not a regulated activity in BVI. All right, this is something that we have to be very clear. Right. However, in the BVI, you have your virtual asset service provider regime, just as with many jurisdictions. Question that a lot of founders have to consider then is whether they want to go into BVI to set up their operating company that will fund their project, or they go to a less regulated jurisdiction, for example, Panama. All right. If you guys see here, the token issuer is actually in dotted lines. Reason why so is because more often than not, to save cost, right? Most of the projects our clients, and we would also recommend that, to actually just combine and use one single BVI entity for the token issuing, and of course, the operating company. There is, of course, that legal principle of segregation of assets and liabilities, right? Because, for example, if you don't want any issues arising from the token issuance to affect your operating company that funds your project, then you would have two entities. Honestly speaking, we think that the risk is minimal. So we generally, from a cost-effective perspective, just tell our clients to set up one entity. One thing that I will also touch upon and remind you guys later is, when do we actually need to set up the foundation, right? When do we need to set up the BVI entity? Frankly speaking, a lot of service providers out there, law firms will tell you, okay, we set it up from day one. We would adopt a different approach, because the moment you set up companies, as you guys would all know, you incur recurring costs, right? There is no necessity in doing so. Why set up a foundation when your TG is, let's say, 6 months later, a year later, right? So there's no necessity to do so, and you want to save costs, right? However, let's say you want to enter into a SAF for purposes of the fundraising, right? Then yes, we would recommend setting up just your BVI entity to sign the SAF, to execute the SAF itself. All right. In terms of timing for the foundation, generally it takes about 2 weeks to 3 weeks to set up a foundation, subject to KYC. And then thereafter, because it's a sole shareholder of your BVI entity, if you had not set up your BVI entity for purposes of entering SAF, factor in that the entire structure setup, i.e. your foundation plus BVI entity, which has to be done back to back, would take about 1 month or so, subject to KYC. All right. So this is the offshore side of things. Now, what's the onshore side? So when we say offshore, we generally refer to offshore jurisdictions, islands, right? Cayman Islands, territories, BVI, Panama, etc. Seychelles, SVG, right? St. Vincent and Grenadines. When we talk about onshore, right, then that's the typical countries that we know of, right? Singapore, Hong Kong, Dubai, Delaware, and it's my hope that Vietnam would likewise be on the choice of an onshore jurisdiction in time to come. All right. So moving on to the onshore side, some clients, founders, projects are they're confused. They always assume that the onshore entity, i.e. your development company, would have to be part of the entire structure itself, under one holding structure. That's not true. And in fact, we would recommend not so. The only connection between your operating company offshore and, let's say, your tech development company, or the company that deals with your HR, deals with your legal, etc., is a service level agreement, right? Why? Why do we have to set up a DevCo here, right? Why can't we simply just rely on BVI? The key reason is because of bank account setup. Right, so banking rules for offshore jurisdictions, especially in the Web3 space, is very, very difficult. Right, it's highly regulated. Opening a bank account, local bank account, is very difficult. But opening a digital bank account might be permissible, but cost would be generally higher. Right, so you need the DevCo to facilitate banking rails, off-ramp rails, etc. Right, and then connected only via a service level agreement. One main reason is also tax optimization, because onshore jurisdictions generally there will be taxes. Right, even in Dubai it's 8%. Right, Singapore is 17%, Hong Kong similar to Singapore, Delaware, thereabouts. Right, so what we want to do is to use the development company to pay any operating expenses that you guys have. But however, revenue comes from the opco, right? Because that's funding your project. So the service level agreement allows you to transfer funds, whether it's in stables or tokens, to your DevCo, so that your DevCo, in exchange for services provided by the DevCo, then your DevCo can either off-ramp, convert the stables to fiat, and pay operating expenses. The DevCo in itself, usually if you're doing a fundraise via safe token warrant, the safe will be entered by the DevCo itself. Let's say you want to save cost, right? You don't want to set up your BVI entity because token issuance is way down the road, right? We generally advise, sure, the onshore company can sign the token warrant. However, before token launch itself, you will novate, i.e. assign the contract from the DevCo to the BVI company, such that everything to do with token issuance is tucked at the offshore side from a regulatory perspective. We would not recommend, given how tight regulations are in onshore jurisdictions, to do anything related to tokens, including token launch. Right? Of course, the founding team members generally will be the shareholders of the DevCo, etc. One last point to note: this may not include Vietnam, but generally speaking, some projects founders, they come from very sensitive jurisdictions. Before Trump came to power, it was the US, China, Korea, etc. Of course, there are regulations in Vietnam, but we do not generally see this issue in the Vietnamese market. So a lot of our clients prefer to opt for a nominee director at the BVI level, because list of directors is public information in BVI, Cayman, and Panama. You can search the name of the directors when you search for the company, right? So from a privacy perspective, some founders do wish for a nominee director to be put in place. I'll just move on. Any questions, please do not hesitate to raise the hands here. Then we can stop and discuss with the team, all right, with everyone. I'll just move on. As mentioned, right, this is the next slide. Similar structure, just that we have replaced Panama, so Panama Private Interest Foundation and Panama International Business Company instead of the Cayman Foundation Company and BVI Business Company. Why? So this is an alternative option for projects who are technically in very regulated space, but wish to operate as a go-to-market strategy from a jurisdiction that is less regulatory restrictive, right? So Panama is one common option. Take note, however, that in March this year, Panama has actually issued a bill seeking to regulate cryptocurrencies. However, it has not been passed, i.e. it's not law yet. So be prepared. Even if you opt for Panama, take note that there might be times down the road that Panama might likewise introduce their own regulations restricting or regulating cryptocurrencies, and perhaps either a license might be required or some kind of approval might be required for certain business lines. Although, take note that Panama, by virtue of its position in the world in terms of its economy, they have to rely heavily on inbound investment from overseas countries. It is unlikely that they will implement such a tight regulation of cryptocurrencies itself. All right. Otherwise, no change to the entire structure. This is commonly what we see in the market itself. Take note, as mentioned right at the start, this structure is in no way applicable to all projects. For example, if you are launching a stablecoin project, you need to mint synthetic asset, etc. Then there will be different structures that we have to consider. Likewise, if you're operating a swap, a DEX, etc., there are different strategies put in place also. So I'll move on. This slide is something that is very important. I want to give you guys a high-level thought process of the regulatory roadmap, right, that you should consider for each and every one of your own projects, right? So first thing first, where is your business located, right? And there are different jurisdictions in question, i.e. where are you incorporated? Where's the country of your entities, right? Where are your team members located? Primarily the founding team members, right? And where are your customers primarily located? Of course, we will say we are running a global business, it's Web3, right? What are you talking about? However, you will know what's your go-to-market strategy. You will know which jurisdictions you're likely targeting, all right? Then where are your banking rails, right? So these are very, very important. For every jurisdiction that you set up an entity, to the extent possible, other than offshore jurisdictions, try to get your banking rails set up, your on-ramp, off-ramp service providers there set up, all right? Second point, please ensure that all your licensing regulatory requirements are satisfied, or at least you have considered those issues, right? And as mentioned, there are several jurisdictions. It's not simply where my company is located. I think a lot of people have this misconception, right? If I set up in Singapore, I only care about Singapore regulations. That's not true, right? There are three key jurisdictions you need to be able to consider. One, your place of incorporation, as I said. Second, the location of the actual business operations. Third, the location of your customers. The advice that we commonly give to project founders is you don't have the runway. Of course, if you are fundraising, you can fundraise 5 to 10 million, right? By all means, right? You will penetrate all jurisdictions. However, if you're doing initial fundraising, your runway is assumingly tight, then deploy a go-to-market strategy very, very strategically, right? So identify, let's say, 1 or 2 key jurisdictions where you know regulations might be less strict. Go there first, right? Explore the regulatory issues, use that as a base to build up the numbers, the metrics, etc. Then we will expand as time goes by, right? Third thing to consider, right? Are your business activities licensable, or are they regulated? Right, so we have identified some of the common projects, business lines that we have seen in the market. As mentioned, your stablecoin projects, whether or not you're launching a synthetic asset backed by a certain asset class, you are minting your own stablecoins whatsoever. That's a highly regulated space. Second, if you're offering on-ramp, off-ramp services. Third, remittance services, whether is it in fiat, whether is it in crypto, both of which would trigger different regulatory considerations, right? One is the crypto regulations, 2, banking regulations, right? Third, are you operating a lending protocol, DeFi protocol, etc., staking, etc., right? Last, of course, if you're doing a tech dev infrastructure business, probably less regulated amongst all, but something to also consider, right? Fourth, obtain licenses, right? Employ risk mitigation strategies, right? As part of the go-to-market strategy. Fifth, establish compliance frameworks, policies, and processes. Take note that regulatory risk is always there, right? It's omnipresent. You cannot eliminate regulatory risk, right? Unless, of course, as mentioned, you have so much runway that you can employ all the law firms around the world to clear you on the regulatory front. However, right, if you don't have those resources, regulatory risk is present. The other thing you need to consider then is enforcement risk, right? And how you balance that with your commercial goals, right? So be strategic, deploy risk mitigation strategies. If the commercial goals outweigh the regulatory and enforcement risk, then we would recommend, let's go ahead with the jurisdiction. We are not the big fish that the regulators will find. However, if you realize that as time goes by, your traction, your user base is ever growing, then yes, subject to how much runway we have, we will explore the regulatory side of things. Okay, so as I mentioned, what are some of the risk mitigation strategies, right? So take note, as mentioned, it's very fact specific, dependent on your business line itself, but rely on licensing exemptions, right? Get counsel to support you guys, understand what the regulations are. Second, whether there are exemptions, right? Structure your activities as non-regulated as possible. I always like to use this example. So for example, founders that are perhaps looking to build payment infrastructure, right? You want to facilitate cross-border transfer powered by stablecoins, right? You can always build your UX UI first. You build your API, etc. Then your API. Then behind the scenes, right? If you're a new project in the market, tap on partners that have the relevant licenses. Of course, commercially, you have to give up something, which means a portion of the profits. You need to give a percentage cut to your partners. But as compared to wasting resources to get the regulatory stuff settled, whilst not knowing exactly how you guys might perform in the market, this might be a good strategy. All right. Second, segregate your offshore, onshore businesses, as I mentioned, right? Offshore for all your token-related stuff, etc. Onshore, HR, legal, payments, of basic payroll, operating expenses, etc. Right. Third, as I mentioned, work with licensed partners. So take note, there is a key difference between using your licensed partners as subcontractors and offering services alongside your licensed partners. Right. So if you want to expressly tap on your partner's license, right, on your website, your terms of use, you need to expressly identify that those partners that have the licenses are actually operating the back end, right? So let's say it's the stablecoin transfer is powered by party A, right? The off-ramping is powered by party B, right? And what you guys are doing is just simply providing the interface, the front end, all right? Because then this mitigates your regulatory risk because you're effectively not simply operating a business unlicensed, right? Having customers in crypto-friendly jurisdictions in your terms of use, you need to identify and geo-block restricted jurisdictions, right? This also depends on kind of business line. Just using an example, prediction markets, right? Certain countries expressly ban prediction markets or identify prediction markets as online gambling. And if you're unlicensed, it's of course bad, right? So the likes of Singapore, Taiwan, France. So in your terms of use, if you're operating a prediction markets platform, you should geo-block these countries, right? Last, perhaps relocate your staff to a less crypto regulated jurisdiction. Touching on marketing, right? Something that I think is very important in our entire Web3 industry. Take note that there are also restrictions in terms of marketing, right? By virtue of it being a restricted jurisdiction, you technically should not market in the jurisdiction, right? So rely on geo-blocking, as I've said. Second, reverse solicitation. What this means, right? You cannot actively go and market, but however, if there is an inquiry from a potential user or partner, that's a different story, right? Because there's no active solicitation on your side. Disclaimers, contractual provisions, add that within your contracts, your partnership contracts, your terms of use, etc., and privacy policy. The key point I want to stress here in red is that no strategy is 100% effective, right? As mentioned, there's always a balancing act between your commercial goals, regulatory, and enforcement risk. You are a founder yourself. You have to make that judgment call. We, as your legal advisors council, will guide you on what's the best way to adopt strategies in light of regulatory framework. However, you guys will have to weigh that against your commercial goals. And to the extent possible, if you think it's a worthwhile decision to penetrate the market, then let's be strategic. All right, I'll move on. Yeah, so some key considerations as a means of refresher, Cayman BVI Panama, take note the main consideration is the regulated nature of the business itself, right? Do you need a foundation? Not necessary, right? Unless you are, for example, intending to implement a DAO and you need to use the foundation as a legal record, right? Of course, right, for token issuance, there is also a tax consideration. If you set up a foundation and shareholder list, etc., technically taxation occurs at the Cayman side, which is tax-free, right? So these are things that we have to consider. Rope in tax expert also, right? Timing, I think I don't have to explain this. When do you need to set up a foundation? I would say about 2 months before TG would be good. A lot of clients, yes, we always say 2 months, right? But please make sure that you also line up with your listings, right? Because the listing teams in the different exchanges would expect to do due diligence on your corporate structure. And then sometimes time is of the essence. A lot of our clients delay till way later to save cost. Then they get very pressured and stressed because they have to line up everything, including with the legal requirements of the exchanges themselves, right? So something for you to take note of. I would say we would recommend 2 months. That would be a sufficient buffer itself, right? Relationship between your DevCo, OpCo, foundation structure as mentioned, service level agreement, right? Of course, eventually as you scale, if you have different business lines, you need to have a holding company structure, then that's a different question altogether. We can help you strategize on that. Key thing, always remember segregation of assets and liabilities. Using an example, once you issue your tokens at the BVI side, you should, to the extent possible, funnel and distribute your tokens as part of the treasury to your foundation level, right? Because from the foundation, as best as possible, should not enter into any contracts with third parties, right? So as to minimize any enforcement action against the treasury and the foundation, right? That's all I have for now. Before I move on to founders agreement, any questions from the floor? If not, you can ask me later after this session or so. Okay, let's move on to founders agreement. I think this applies, and it's actually very important, but often ignored or neglected by founders, right? And this founders agreement will apply if your project has at least 2 founders, right? So why do we need a founders agreement, right? It's sometimes an investor expectations. Your VCs, before they invest, they will do legal due diligence. They will expect you guys to give them a copy of the founders agreement. Sometimes it might not be a condition for closing for them to invest, but it might be a condition subsequent, right? So depending on your negotiations with your investors, ultimately it may be a requirement. The only question is whether you need to provide it before fundraising or after fundraising itself, right? Second, founders agreement is important because it identifies each of the founders' roles, rights, and obligations, right? Third, clear structure for resolution of founder conflicts. Why do I say that most founders actually neglect a founders agreement? Because when we first start out, number one, it doesn't seem to be an important aspect of your business, right? Second, relationships are very good, right? You and your co-founder, you guys are hustling, everyone's happy, right? The tricky part is when a dispute actually happens down the road, you guys have nothing in black and white to fall back on, right? Last, the founders agreement also serves as a protection against founder departure, right? You guys must be incentivized to hustle alongside your founder, your co-founder, for as long as possible. It's also generally a requirement by the VCs to expect that founders stay on in the project itself. So what is a founders agreement? In short, it's an agreement between the company, your company, and the founders, at least 2 founders, of course, right? Which sets out the key terms and conditions regulating the affairs of the company and the rights and obligations of the co-founders prior to any financing from third parties. It can be after financing, but then it will be a condition, right, subsequent to financing itself. So I'll just touch on the key clauses, right? I won't delve into it. I don't want to be too technical, right? I'll just keep founders' contributions, roles, and responsibilities. I think it's very obvious. One thing to note is we would advise to set KPIs, even for co-founders, right? That's very important. Then assignment of IP, I think self-explanatory. Anything that you guys build should technically belong to the company, not to one co-founder alone, right? Deadlock, right? So what are the provisions to help remove a deadlock when there is a dispute between the founders, right? So for example, who can make a call? Who has veto power over certain issues in the company, right? For example, Long might have a veto power on treasury, right? I have a veto power on technical side of things, right? These are examples. It's ultimately commercial. You guys have to discuss, then the legal counsel will drop it. Restrictions on transfer of ownership. These are very important, right? So lock up on the founders' shares. Founders cannot sell their shares within X period of time from the date of the agreement itself. Right of first refusal, right? What does that mean? It means that if any of the founders, after their lockup period, want to sell their shares, either the company or the other co-founder might have the right to buy those shares first before it goes into the open market, right? Of course, there must be exemptions, right? Permitted transfers. So, for example, transfer to for tax reason, one founder needs to set up a holding company in offshore jurisdiction, right? Permitted transfers basically allows for that transfer to the holding company itself, right? Because the founder still remains, although indirectly through the holding company for tax purposes. Bad leaver and good leaver provisions, reverse vesting. I think this is very important. I think not many founders are acquainted with this concept. So, for example, right, as by way of contrast, when you engage a contractor, your employee, generally you'll be actually issuing shares which are vested or tokens, right? But for you guys as founders, when you set up the company, all the shares are technically vested from day one, right? You own those shares on the record. So we, on the legal side of things, we came up with this concept called reverse vesting, right? I need Long and myself to both stay for 4 years in the company, right? I know that our vesting is 4 years, right? So monthly investing over the course of 4 years, right? However, we both each have our own shares already. Reverse vesting is very simple. So let's say Long leaves at the 2nd year mark, he's technically only supposed to get 2 years worth of shares, right? So what happens to his unvested shares, right? Then the company have the right to buy back the shares, right? And then you will have two concepts, right? The vested shares and the unvested shares. And to complicate things, you also have a situation where Long resigns without a good reason, right? Or Long gets fired because of a good reason, right? So effectively, bad leaver and good leaver, I think it's quite self-explanatory. A bad leaver is someone who leaves the company without good reason or is fired from the company because he or she breached something, like in this case, the founder's agreement, or is not performing his responsibilities as the founder. By virtue of you being a bad leaver, technically, you should not have get as many rights as good leavers, right? So what happens is when, assuming I leave the company at 2 years up, I'm a bad leaver, right? My unvested shares should be sold to the company at nominal price, $1. My vested shares, perhaps the company has the right to buy back at a discount, right? So for example, 50%. Underlying rationale, you want to incentivize the founders to contribute to their best ability for as long as the duration is. So for example, we generally see 3 to 4 years, right? On the flip side, you also want to disincentivize people from leaving the company without good reason. All right, so you need to understand what's the underlying rationale for all this kind of clauses. Then you guys can discuss commercially. All right, so valuation of shares expected, it should be put inside. Restrictive covenants, simple, non-compete, non-solicit. If one founder leaves, he cannot bring any of the clients, cannot bring any of the team members within X period of time. What do I mean by reasonableness? All this kind of restrictive covenants are always subject to the evaluation of reasonableness. It cannot be unreasonable, right? Because you have to strike a balance between protecting the company's interest and the other co-founder who remains in the company versus giving the departing co-founder the flexibility to run his other businesses, etc. Right? So generally, if the clause is not reasonable, it may be struck down by the court. Right. So when we ascertain reasonableness, we look at factors, for example, geographical limitation, right? Where do those restrictive covenants apply? Right. Second, time of the restrictive covenants, 3 months, 6 months, generally permissible, right? And then last, whether or not the restrictive covenants, for example, the non-compete, is only strictly restricted to the exiting co-founders' scope of work in the company before he leaves, right? That's important also. All right. So I'll move on. I hope you guys have gotten a better understanding of the key clauses in the founders' agreement. Next, this is not part of the topic actually, but I thought it's still helpful, right? I'm sure Long and the rest of the team, all the other mentors have actually gone through fundraising documents so many times. You guys as founders are very familiar. What I intend to do and what we intend to do is to have some food for thought questions, right, that commonly arise in the market. So do you need a term sheet? Is a term sheet binding, right? No, you don't necessarily need a term sheet. It's not a requirement for fundraising. A term sheet generally is non-binding. However, if parties expressly identify in the term sheet that a certain clause is binding, for example, no short clause, confidentiality clause, etc., then a breach of that would be akin to a breach of contract, and then there will be damages, right? Then what's a no-shop clause, right? It basically means that for X period of time, let's say a month, if you are dealing with a lead investor restricts you from actually using those terms in the term sheet to get other lead investors or to explore the market, right? So that's a no-shop, okay? Second, is the founders agreement required in order to sign an investment document? I think the answer should be self-explanatory. If not, it means you guys haven't been paying attention, right? So it's technically not required, right, in order for you to close a fundraising round. However, right, the VCs might expect for you to give it as a condition subsequent, right, i.e. X period of time after the fundraising closes. Third, is the founders agreement and the shareholders agreement the same? This is a very, very common misconception. Everyone thinks that at the start of the company, you need to enter into a shareholders agreement. That's not necessarily true, right? As mentioned, a founders agreement is an agreement between the company and the co-founders, right? However, a shareholders agreement is commonly entered into only when you have done a price equity round, right? So for example, your Series A, when you actually do a price equity round, your safe holders get converted into investors. With so many investors on your cap table, then you need to enter your shareholders agreement, right? However, just like you recall, I said not necessarily so. I didn't say not so, right? Meaning it's not definitive. Why? Sometimes you may still need a shareholders agreement because some companies do have direct investment, equity investment right from day one, right? For example, a family office comes in with equity. Then yes, they are not founders, so you need a shareholders agreement, right? Safe token wallets and stuff negotiable. Yes, of course they're negotiable, just like any other contract, right? However, the rule of thumb here is that you generally don't want to negotiate these investment documents with any of your angel investors. It's a waste of time, right? You want to keep the template investment documents, the one that you have finalized, as consistent as possible across the entire fundraising group of investors. However, you will negotiate, of course, with your lead investors, right, or any other strategic investors you're looking to get. But more importantly, take note, your special terms, your preferred terms with regard to your lead investors or strategic investors should be in a side letter, right? It shouldn't be your main documents, right? Next, your tokens are not listed on a centralized exchange. Would you give your early investors the right to sell the tokens in the secondary market? If yes, what further protection should the project seek, and how do we do so? Answer the first question, yes, of course, right? You want to attract your investors, you want to give them the flexibility to exit. That is also in your favor because then you can get the fundraising done. However, as mentioned, you need protections. So what do we do so? For example, adding in a right of first offer, right of first refusal, right? That expressly provides in the investment documents that if the investors seek to sell their tokens in the secondary market, they have to let the company know first. Company has the right to buy those tokens first, right? Of course, whether you want to apply a discount based on market rate, etc., it's commercial. But main reason why we want to put that protection so that your investors don't unnecessarily dump the market, right, and affect your charts. You buy back the tokens from them, then you pass it on to your market makers. Market makers will help you deploy the market. All right. Last, how many investors are optimal? Of course, this is a very, very commercial decision, but we would generally recommend, to the extent possible, get 2 lead investors, 2 or 3, at least 2. Why? If you get 1, right, you wouldn't be stopping at the first fundraising round. There'll be subsequent fundraising rounds, right? If your only lead investor doesn't come through in the next round, then it doesn't show as a boost of confidence, right, from your lead investor. However, if you have 2 lead investors, perhaps the possibility of one of them coming in will be high, right? So that's something for you to think about also. All right, I think I'm good for time. Thanks very much. I hope that this has not been too much of an information overload and that this was helpful. Happy to now pass the time over to the floor. Please ask any questions that you guys might have, irrespective of whether it pertains to today's topics. To the extent that we can answer, I will answer them. If not, Mikhail and I will get back to you guys async after this. Right? Thanks very much, guys.
Okay, let's open the floor for questions. Anyone have any questions? Like, I think a bunch of you guys are working on a number of things like DPIN, real world asset. You have any particular question, or you have any like general question about the area you're working in, or like, stuff like that?
Okay, Long. So sorry, just one point for those founders that are building RWA projects. I think one aspect is, of course, the regulatory framework, right, to build your platform, tokenization of the assets itself. But on the other hand, it's also distribution, right? I think that's actually more important, right? I.e., once you guys have tokenized a particular asset, right, then you have to consider distribution. For distribution, if you are an early project in the market, what we would suggest is go and tap on those licensed tokenization platforms out there, right? They run that business of building the infrastructure to help you tokenize your asset under the umbrella framework and then to distribute, right? More importantly, you need to ascertain in choosing this kind of infrastructure providers whether or not they have experience dealing with the underlying asset that they are tokenizing. Because you need to make sure that they have that market user base or investors who are willing to take in those tokens, right? That's something I want to share based on our market experience. Thanks, Long.
Cool. Oh, by the way, so we have our media guy Jack in here. He wants to do a short recording of you answering a question for like like the video short that we usually publish on Twitter. So can I ask you to just stop sharing first?
Yep.
All right. Okay, Jack, is that good?
Yes, it is good. Yeah.
Hi, Jack.
Okay, hi. Nice to meet you, Mark. So I'm
Nice
doing
to-
videos for the Real Fun Cam right now. So I might need to ask you a questions. Um, can you change the resolution of your camera to HD?
Oh, good question. How am I supposed to do that?
So go to the more option, like the dot dot dot,
Yep.
and go to
Video.
settings,
Okay. Yes.
and
That's-
then go to videos, and then just change everything to like the
Okay.
top resolution.
Yep. All done. Jack, is that okay?
Yeah. It's good. It's good. Oh, okay. So, the question is, what are the top 3 legal pitfalls to watch for?
Wow. Very, very good question.
Uh, Before you answer the questions, can you introduce yourself first? And then for example, hey, my name is Mark. I'm from Outlaw, and this is 3 legal pitfalls to watch for. And then you answer.
Okay. Sounds good.
Yeah.
Yep. I can go ahead whenever you're ready, Jack.
Okay. Okay. Yeah, I'm ready now. You can go.
Yep. Hi, everyone. I'm Mark. I'm co-founder of Outlaw. We support Web3 projects in the space as fractional in-house general counsel and strategic advisor. 3 of the common key pitfalls that we see in the market. 1, founders not entering into a founders agreement right from the onset, and subsequent founders disputes without a founders agreement will lead to the ultimate failure of the project itself. Second, common pitfall is that founders actually think that they need to do a fundraising and that a fundraising is always good, right? Instead, please consider both the commercial side of fundraising and, of course, the legal terms of your fundraising. Always get counsel to advise you on the legal terms, because not all fundraising may be optimal for your long-term commercial goals. Third, common pitfall is with respect to regulatory framework, right? Please do not only consider the jurisdiction of incorporation of your company. You need to consider other jurisdictions, for example, the markets that you are supporting. Second, where your team members are located. And third, where your actual business operations are based. Thanks, Jack. That's all.
Is that good?
All right. Yeah. Perfect. Yeah. Thank you.
All right, thanks,
No
Mark. I
problem.
think we'll share the video when it's ready.
Yeah, sounds good. Thanks, Long. Anyway, guys, we have about 12 minutes. To the extent that we can help with any questions. Oh, hi, Carl. Nice to meet you. Please go ahead.
Yeah, hi Mark. Thank you for your presentation. So I have a question. Actually, you mentioned about the real access project that we are working a real access project, but we are like an aggregator where we gathering informations, data from other issuer platforms. Yeah, we are not the issuer platform, but we kind of like aggregator, including data, and later we allow user to trade on the tokenized assets. Of course, we are still follow the regulations from issuer platforms. But do you have any advice for the aggregator platform like us?
No, for sure. Very, very good question, and Carl. So 2 things to note. First is, in your terms of use, you guys have to be expressly clear that you guys are providing the front-end interface as an aggregator, right? Of course, I presume you guys will have the APIs for all the other tokenized platforms that allows people to click, let's say, trade, and then get linked to the platform itself, right? Yeah, so first thing first, your terms of use must expressly identify your company's role, your business role as an aggregator itself, right? Then in the usual disclaimers, etc., etc. Second, from a contractual perspective, right? Let's say when you onboard each of these tokenized platforms for trading as your partner, to be on your aggregator platform, you need to make sure that you expressly insert contractual provisions, right? So representations from your counterparty that they are licensed in the respective jurisdiction that they're operating in, get the necessary indemnities from them, etc. So this, as I say, is the contract between your company and those partners that you're working with, that you're aggregating. Is that clear?
Yeah, so it means every tokenized I want to onboard into my platform, it had to be some specific agreement between us and let's say the issuer platform.
Yep, that's correct. I presume so, and I also presume from a commercial perspective that you would want to do so because not only do you want to get contractual protections, but you also want to, for example, insert commercial terms whereby you get a percentage cut of the trading fees if someone accesses the platform, the trading platform through you guys, right?
Mm.
Yeah.
Yeah.
All this should be worded in the contract itself.
Okay.
Yeah.
And
Question, because as an aggregator, your regulatory exposure is definitely lower than the actual trading platform itself.
yeah, but do we need any additional like license for that? Because like beside the official license from issuer platforms.
Yeah, good question. So ultimately depends on how you guys are building your interface, right? We would suggest, right, if you want to go to market first with the least regulated route, then do not incorporate any swaps within your platform, right? So anything must be redirected to an external platform as best as possible.
Mm-hmm. Okay.
Okay.
Yeah. So the same in our platform we have prediction market factors, but again it's just like an aggregator. So we pull the related bet from market from poly market or country to our platform, but then still link to the prediction market. So the same things, right?
So the same concept applies where, to the extent possible, if you guys don't have the budget to explore the regulatory route first, then we would suggest to simply fulfill the function as an aggregator. If any interested party wishes to use your aggregation platform, if they want to trade, they will be linked via an API to the external platform that you're aggregating.
Mm-hmm.
Okay, and of course, just to be very safe, as I mentioned, for prediction markets, there are certain jurisdictions like Singapore, Taiwan, France, and perhaps more down the road that expressly identify prediction markets as online gambling, and you cannot operate an unlicensed online gambling platform. What then you do is, notwithstanding that you are operating an aggregator, just to be safe, just geo-block those jurisdictions. Okay, and take note, guys, there are two concepts of geo-blocking. One is terms of use geo-blocking, which means you expressly identify the restricted jurisdictions in your terms of use. Second is the technical one, where let's say it's basically a IP blocker, right? I think you guys are all technical block founders. You guys are aware of that. I cannot access prediction markets from Singapore, so there is IP blocking. As an initial go-to-market strategy, it's always a best efforts basis. So terms of use geo-blocking suffices for now. But once you guys get bigger, right, then I would suggest perhaps consider employing technical geo-block. Whether the users actually use a VPN to come through, that's not your problem anymore. Okay, because you have undertaken best efforts basis to geo-block. I'll pause there. Thanks, Carl. I hope I've addressed all your questions.
Yeah. Thanks. Thank you.
No problem. Yeah. We have about 5 minutes left. Any other questions?
Let's do one more questions. Does anyone have a last questions? Okay, maybe I'll ask, right? So I think right now there's new like regulation being passed in Vietnam. There's a lot of that have to do with like central exchanges, crypto asset holding, and then like users are required to, like, for example, like if they hold something on Binance and Binance does not get approved, they have to move asset to like another chain that is regulated by the government. So like a lot of very similar with the whole Binance FTX saga in Singapore back then. Do you have any advice for like, you know, crypto builders and crypto users who trying to manage their treasury? If that's the case, like what would be the best strategy for them to like manage the treasury, like crypto asset? Do they have to comply with uh do they have to comply with the like, local regulation, or should they be moving somewhere else? Like maybe just some general like guidelines.
Yeah, of course. Thanks, Long. Actually, very, very good question. I think first thing that I need to caveat is, of course, I'm not a Vietnamese law expert. Always happy to rope in our Vietnam law partner to help with that. However, I think one thing that I wanted to add, and I should have added into the corporate structuring side of things, is we also help, and we have seen a lot of situations where the foundations actually set up a separate offshore entity. It can just be a simple BVI company for trading purposes, right? So effectively, you set up a BVI company, and then we can help you onboard with the different centralized exchanges, their institutional accounts. The KYC will always be done on the underlying UBO of the entity itself. Of course, if you're Vietnamese, technically you have to comply with Vietnamese tax obligations, local regulations, but that's also one way to actually get some privacy, or I would say to navigate or circumvent, right, strategically. But it's not foolproof, by the way, right? Because technically speaking, if the offshore jurisdiction had a treaty with Vietnam, technically all information would pass and would flow, right? So that's one. Second, if you are working with co-founders that are from other jurisdictions, one thing that we commonly deploy as a strategy is also to use your other co-founder as a nominee for you, right? Which means you don't appear on record as any shareholder whatsoever. Of course, what you will be relying upon is some form of trust. Second, a black and white contract, right, between you and your co-founder. So that's two. That's what we see in the market. Third, set up the offshore structure, right? Because it's shareholderless, effectively, you guys can manage the treasury through the foundation itself, deploy it into different strategies, staking platforms, trade, etc. Right? So the treasury is parked at the foundation level, where it's not owned by any specific individual, including a Vietnamese citizen. Right? So that's important also. Yeah. Otherwise, I think those are the key strategies we've seen in the market. I hope that addresses your question, Long.
Makes sense. I think Arno have a question, but he cannot. Well, anyway. So I think we're running out of time. Any final advice? Any final message for the builders and founders who are looking to set up their Web3 business?
Yes. One final one. Ultimately subject to your business, your commercial call. But I think, as you guys can see from the market itself, right, the token play may not be the end-all and be-all, right? I think a lot of Web3 founders think that TGE is the end, right? Getting listed on an exchange is the best thing you can achieve as a founder. That's not necessarily true. The fundraising landscape, the entire landscape has shifted such that now more VCs are looking at actual numbers, user metrics, revenue, profitability, right? If to the extent you can run a business and simply rely on the revenue that is coming in akin to a Web2 business, right, please do so, right? Because that token exit play is not what we can see in the market, as you guys are aware. I think second tip is, or second recommendation of what we see in the market, please also take note that you guys have leverage power to negotiate with the exchanges. If you're deciding to go with the deployment route, the token play, don't simply accept as is, because you guys might suffer down the road, right? Because they take a huge chunk of liquidity. Then third thing, in terms of tokens, I think one key strategy is also how you guys want to manage your treasury, right? And I think I've mentioned this again. If you don't need to fundraise, please don't do so, because you are effectively subjecting yourself to obligations to your investors, right? And that may not necessarily be a positive thing if you have not thought it through, right? There are many ways of exiting, not simply through a fundraise itself, right? Consider mergers, consider acquisitions. That is getting very rampant in the market also. Okay, that's all I have to share. Thanks so much once again. Appreciate it, Long, for the invitation. Feel free to reach out to us if you have any questions. Long has my contact. We have flashed that contact on screen just now. But always very happy to help, especially if you're part of the Square Down ecosystem.
Okay, thank you, Mark. Thanks for the time, and let me end the recording, and I think we can wrap up here. We'll share the full recording as well, so you guys.